Aloha, I am John Roth, an estate planning attorney, and this is Just Ask John, where I answer your questions about estate planning. Estate planning is the proactive approach to plan in the event of incapacity or death, which usually will include the documents, a will, trust, power of attorney, advanced healthcare directive. Today, the question that I'm going to address is, what is incapacity? In the past, I've thrown out the term incapacity when talking about various aspects of estate planning. Capacity has a spectrum, part of it in your life where you have great judgment, and then good judgment, then bad judgment. You're competent, maybe less competent, capacitated, and eventually there could be a time where you're completely incapacitated and you're unable to mentally understand what is going on. But that spectrum includes various points in your life where you may need help managing your own affairs. So estate planning, oftentimes people think of death, but a large majority of the time estate planning comes into play during your life if you're unable to manage your own affairs. To set up an estate plan, there is a threshold for the type of capacity that you have to have. Estate planning is a proactive approach. If you do not have that lowest threshold of a testamentary capacity, it is too late. You're unable to set up an estate plan. So hopefully you set up a plan during your life before anything happens to you. Testamentary capacity is determined, generally speaking, by a few different standards. It means you know who you are, you know your family members, you know generally what assets you have, and you understand the overall plan regarding who gets what. That is testamentary capacity. With increased services in healthcare, people are living longer, so it's increasing the likelihood that you will be alive and unable to manage your own affairs. The older an individual is, the more likely that there may be some cognitive decline, which at some point, if you're not exercising great judgment, you may want a family member, an agent, to step into your shoes and have the authority to pay bills, make decisions regarding finances, for example. Or incapacity may be a temporary thing where if you're in an accident and unable to pay your bills and take care of your affairs for a brief moment in time, your agent can be set up for those types of scenarios and be able to step in and help you for the period of time where you need that help. But at some point in your life, when you're not exercising great judgment, you may need someone to step in and help pay bills. That would be a power of attorney, or maybe you want to have somebody as a joint owner or a signatory on a bank account. We'll talk in future videos about what it means to have someone be a signatory or a joint owner on a bank account. So hopefully you understand a little bit more about what I mean when I use the term incapacity. If you have future questions, you can write down as a comment below or visit our website, hawaiitrustlaw.com. Thank you for joining us. Aloha.